Applying for a UK visa can be a stressful and time-consuming process, especially when the outcome does not go as expected. Every year, thousands of visa applications are refused by UK Visas and Immigration, often leaving applicants confused and frustrated. In this video, we will explore in detail the most common reasons behind UK visa refusals and explain how you can appeal or challenge such decisions effectively. The first, and perhaps the most frequent cause of refusal, is incomplete or incorrect documentation. The UK immigration authorities are extremely particular about supporting evidence. If even one required document is missing, expired, or inconsistent, your application may be rejected without further consideration. Many applicants fail to include documents like bank statements, employment letters, or proof of relationship in family or spouse visa applications. The second major reason is insufficient financial evidence. The Home Office wants to ensure that applicants can support themselves without depending on public funds. If your financial documents do not clearly show stable income, savings, or sponsorship, the visa officer may doubt your financial capability. Always provide up-to-date bank statements, salary slips, or business accounts with proper translations if necessary. The third reason relates to incorrect or inconsistent information in the application form. Even a small mismatch between the details you provide in your application and the information in your documents, such as job title, dates, or travel history, can lead to refusal. The immigration system operates on strict integrity rules, so honesty and consistency are vital. Another common issue is failure to meet the English language requirement. Many visa categories, including student and spouse visas, require proof of English proficiency through an approved test such as IELTS. Submitting an outdated test result or a certificate from an unrecognized center can lead to rejection. The fifth reason is lack of genuine intent, especially in visitor, student, and spouse visa categories. The Home Office often assesses whether the applicant truly intends to visit, study, or live in the UK for legitimate reasons. If your documents or statements do not convincingly show your real purpose or your plan to return home after your stay, your application may be refused under the genuineness requirement. It is also common for applicants to face refusal because of immigration history or previous violations. If you have overstayed a visa, worked illegally, or provided false information in a past application, the Home Office may use that as grounds for refusal. Being transparent about your history and explaining any mistakes clearly is essential. The seventh reason involves criminal record concerns. A previous conviction, even for minor offenses, can influence your application depending on the severity and timing of the offense. The Home Office conducts background checks, so concealing such information can be considered deception. Another ground for refusal is failing to meet specific eligibility criteria of your visa category. Each visa type, student, skilled worker, family, or visitor, has its own set of requirements. For example, a student visa requires a confirmation of acceptance for studies, CAS, and a skilled worker visa requires a valid certificate of sponsorship. Submitting an application without fulfilling these core conditions almost always results in refusal. Additionally, some applicants face refusal due to lack of credibility during interviews. In certain cases, the Home Office conducts interviews to verify your intent, financial situation, or study plans. Nervous or unclear answers, contradictions, or inability to explain your situation can create doubts. Preparation and honesty are key to passing such interviews. Finally, technical or administrative errors can also occur. Sometimes, applications are refused due to processing mistakes or misunderstanding by the caseworker. In such cases, it is crucial to identify whether your refusal was lawful or based on an error. Now, let's move on to the most important part: what to do after receiving a refusal. When your visa application is refused, the first step is to carefully read the refusal letter, also known as the refusal notice. This document outlines the exact reasons why your visa was rejected and states whether you have the right to appeal, request an administrative review, or submit a fresh application. If you believe the decision was made incorrectly, for example, if the officer misunderstood your evidence or ignored certain documents, you may be eligible for an administrative review. This is a process where a different caseworker re-examines your application without new evidence. Administrative reviews are suitable for points-based visas like student or skilled worker categories. However, if your visa category allows for a full right of appeal, you can take your case to the first-tier tribunal, immigration and asylum chamber. This is a more formal process where you or your legal representative present your case before a judge. You will have to submit your appeal within a specific time, from usually 14 days if you are in the UK, or 28 days if you are outside the UK. During an appeal, you can provide additional evidence, witness statements, and legal arguments to support your case. It is strongly advised to consult an immigration lawyer or accredited advisor before proceeding, as a well-prepared appeal can significantly increase your chances of success. Another possible option, depending on your situation, is to submit a fresh application instead of appealing. If your circumstances have changed, or if you now have stronger evidence to fix the issues mentioned in the refusal letter, a new application might be quicker and more practical than an appeal. However, you should only reapply once you fully understand the reasons for the previous refusal. Repeating the same mistakes will likely lead to another rejection and could damage your future chances. If your visa was refused for reasons such as deception, false documents, or overstaying, you may also face a re-entry ban lasting from 1 to 10 years. In such cases, professional legal advice is essential. Always remember that the Home Office assesses each application based on credibility, consistency, and evidence. Therefore, your documentation and explanation must support each other. To avoid refusals, it's important to follow a few practical steps. First, always check the latest Home Office guidelines before applying, as visa rules change frequently. Second, make sure all documents are original, correctly translated, and clearly labeled. Third, explain your personal circumstances in a short cover letter to help the caseworker understand your intent. Fourth, never provide misleading information, even if it seems minor. Honesty always builds trust. And finally, if you are unsure about any requirement, seek advice from a qualified immigration advisor. In conclusion, a UK visa refusal is not the end of your journey. It is an opportunity to learn, correct, and reapply with stronger evidence. Understanding why refusals happen and knowing how to appeal can save you time, money, and stress. Always stay calm, organized, and well-informed. With proper guidance and preparation, you can turn a refusal into an approval and achieve your goal of living, studying, or working legally in the United Kingdom.